Okay, good morning, everybody. Um, I am Rob Baldwin. I am an attorney here in Florida. I help get and keep clients' legal affairs in order. And I am doing this webinar here today because lately I have been getting a number of questions um, regarding estate planning from clients, but not just from clients, from friends and family members, relatives, all over the place. So in the age of Zoom and internet and webinars, I felt it was a good opportunity to take these questions and provide some answers in a community format, provide a little education, and hopefully everybody finds this helpful. I appreciate any comments, any feedback. If there's something that you'd like to hear or more topics to be discussed, I'm going to be doing this here on a weekly basis going forward, just to give everybody little bits of information. So I'm not overloading you with information. Nobody likes to hear a long lecture from a lawyer. So little bits of information, starting today with some basic information. I seem to be getting a lot of basic estate planning questions here lately. People in quarantine, I guess, have a lot of time to sit back and deliberate and think about their planning, or as is most of the time, their lack of planning. A lot of people just don't have a plan in place. So again, I'll be doing this on a weekly basis. Please come back if you like what you saw here today. Please come back, let me know, email me your questions. I've already had some people email me some questions prior to today, and I'll be answering those questions here towards the end. There is a little question and answer feature on Zoom here where you are able to ask questions, and I can see those, and then I will come back and I'll answer your questions. But of course, you're free to call, you're free to email me. I will have my information up on the screen. Okay, so without further ado, let's go ahead and talk about some basic estate planning. And so you don't have to stare at me talking the whole time. I've got some visual aids here that I think will help present the information. All right. So what is estate planning? Estate planning, basically the process of anticipating and arranging for the disposal of an estate during one's life. Now, what does that mean? Estate planning, a lot of people think it's just planning for your death. And it is death planning, but it's not just death planning. It's also incapacity planning. And that's a big part of it. You know, planning while you're still here for what's going to happen once you're gone, or for what's going to happen when you or if you are not able to make decisions for yourself any longer. So the process of estate planning usually starts with most people with some kind of major life event. You know, it triggers them thinking about these things. Marriage, birth of a child, death, divorce, and of course, pandemic will get people to start thinking about these things they're planning. Now, the sooner the process happens, the sooner you think about these things, then the more options, the more flexibility that you have for you or your family and your family. We always say that estate planning is something to do early and often. Why? Why is it important? Estate planning, you're able to avoid guardianship proceedings in the event of an incapacity. If a time should come when you're not able to make decisions for yourself, you're incapacitated, if you don't have any kind of planning in place, then a legal proceeding would have to be instituted against you to have you declared incapacitated, and then a court would appoint a guardian over you. Now, there are ways to mitigate that situation and make it so you don't have to go through a costly and protracted guardianship proceeding, and that is with planning. You're able to designate healthcare surrogates. So if you're not able to make decisions on your own, you can designate somebody who will be able to make those medical decisions for you. You can designate guardians for minor children who you would like to be godparents for your minor kids if you're not here. Written instructions as to what happens to your stuff when you're gone, who will inherit your assets upon your death. And you can use probate strategically, or you can avoid it entirely, which leads me to a question that I am asked a lot. What is probate? I also hear, how do I avoid probate? And why do I want to avoid probate? But first and foremost, what is it? What is probate? Probate, it's a court-supervised legal process involving proving a will, determining who will inherit under the will, beneficiaries, or who those beneficiaries are if there is no will, identifying the assets, valuing those assets, ensuring that the decedent, the deceased person, we call the decedent, ensuring that those debts and taxes are paid, and then distributing the assets pursuant to the terms of the will. And if there isn't a will, then the assets are distributed pursuant to Florida law, what we call intestacy. Florida's intestacy law. They're what dictate what happens to your stuff after you're gone if you don't have a plan in place, if you don't have a will. Sample scenario here to explain this kind of stuff. We've got a little ditty about Jack and Diane. Now, Jack and Diane, middle-aged family here. They have 2 minor children. Jack is an engineer, works full-time. Diane is a stay-at-home mom with the 2 kids. They both own their house together. Jack has a 401k through his employer, through his work. Diane is named as the beneficiary on that 401k when Jack passes away. They both have a checking account. They both have a savings account. They both have a brokerage account. Those are joint accounts. And then there's a life insurance that Jack got through his work. And he never named a beneficiary on that life insurance policy. So it's sitting out there with no beneficiary name, which is not uncommon, surprisingly. So what happens if Jack should die before Diane? Now, again, Jack and Diane did not have an estate plan. They didn't do anything. Under Florida law, everything will pass under Florida law, again, because Jack didn't have a plan in place. The home is going to go over to Diane, jointly titled. The 401k proceeds are going to go to Diane. She was named as a beneficiary. And then all those joint accounts, checking, savings, brokerage, those are joint. Again, under Florida law, they're going to pass to Diane. But what about Jack's life insurance policy? The life insurance policy where Jack did not name a beneficiary. Again, a scenario that we see, unfortunately, too often. Now, because Jack didn't name a beneficiary in that policy, his employer explained to Diane, his wife, that the proceeds are going to need to be paid to Jack's estate, which means that Diane now has to open a probate proceeding, go petition a court to open a probate proceeding for her deceased husband, Jack. Now, because he died without a will, then Florida law is going to determine the heirs of Jack's probate estate. So if we have $1 million under that life insurance policy, that's going to end up going to Jack's wife, Diane, under Florida law, but she was forced to go through the probate proceeding to get there. Now, those benefits were delayed because she had to go through that proceeding. She spent unnecessary time, money, hassle, because there was no beneficiary named and because she had to go through probate. Now, most concerning for Diane, because Jack and Diane were prominent members of the community. Everybody knew them and they knew what was going on with them. She was very concerned because she knew that a probate proceeding meant that their business was going to be open to the public. Probate proceedings are matters of public record, and that bothered Diane. She didn't want the general public to be able to peek through and see their business, so to speak. But unfortunately, there's no way around that with a probate proceeding. So that's where we were when, if Jack were to pass before Diane. Now, if there was an accident scenario and say Jack and Diane died simultaneously, they died together, what happens then? I hear this a lot with many, not just clients, but people in general. Jack and Diane in this situation always assume that their children's financially responsible godparents would be appointed as the guardian. Now, I can't stress it enough that by simply declaring that you want a particular person to be a godparent to your children, that does not have any legal effect. Not without you doing the necessary steps that you need to do to be able to make those people responsible as guardians, as godparents. So in Jack and Diane's situation, they assumed that they're very good friends that had the wherewithal to be guardians. They assumed that they would be the godparents, but unfortunately they died without any planning. They didn't have wills. So Diane's brother, who's a financially irresponsible bachelor, he gets appointed by the court as a guardian because he's the sole blood relative. Not a good situation. Jack and Diane, I'm sure, would not have wanted that. Now, because Jack and Diane's assets are all trapped inside a contested probate proceeding now, that means there are no funds right now available either to take care of those children. And that's for any of their extracurricular activities or for their schooling or anything like that. So obviously not a good situation, and a danger tale of what can happen with a lack of planning. Can this be avoided? It certainly can, yeah. There are two types of estate plans, generally speaking. A will-based estate plan and a trust-based estate plan. Now, let's find out a little bit about what each one of these is. The will. A lot of people are familiar with the will. It's your old-fashioned planning technique. Most people are familiar with what a will is. It provides written instructions as to who will inherit assets after death. So it's really an instruction guide that you're giving to a probate court as to what you would like to have happen with your stuff upon your death. A will also designates guardians for minor children. So you were able to state your preference for guardians for your minor children in your will. Now, a will does not avoid probate. Very important. I get that question a lot. If I have a will, does that mean I don't have to go through probate? And it's quite the opposite, actually. A will is designed for a probate proceeding. And a will is, again, it's the instructions that you would provide to a probate court to have your wishes carried out after your death. So it does not avoid probate. The trust-based plan. This is often used to avoid probate. Trust is also able to avoid a guardianship proceeding. You are able to name your preferred guardian in a trust document. It also allows you to provide written instructions as to what happened with your assets upon your passing. And you are also able to designate guardians for your minor children under your trust. Now, a big distinction between the two, the will and the trust, is a will, that only comes into play once you're gone. A will is instructions at your death. And a trust, on the other hand, it can be operable right now. That comes into play immediately while you're living, and then continues on after you're either incapacitated or dead. So big difference between those two. In a trust, you are able to appoint a trustee of your trust to handle things. You are typically the trustee of your trust while you're living. And then that document provides instructions for who is to be your successor trustee, who will step into your shoes and handle those affairs once you were either not able to any longer or once you're gone. So that document will outline all of those things, and it is not necessary that you file a probate proceeding or have a court order to proceed, anything like that. You're able to just pick up the ball and run with it in the change of under the change of circumstances, so to speak. So they're two very different planning techniques. And the trust, again, it does avoid probate, or it can be used to avoid probate, or it can be used, probate can be used strategically under a trust-based plan. And that's a topic for another webinar. But those are the two basic types of estate planning. You have your will-based or you have your trust-based. And your will-based is designed to go through probate, and it does not come into play until you are dead. Whereas the trust-based is really designed to avoid probate or get around a probate proceeding, and it is alive and active now. Now, we have beneficiary designation considerations. We talked about Jack and Diane with their, Jack had his 401k policy, and he named Diane as the beneficiary on that policy. So when he passed, Diane, as the beneficiary, properly named, received those funds. The problem was with the life insurance policy. You remember the life insurance policy didn't have a named beneficiary. So you really need to make sure that any accounts that you have where you're able to name beneficiaries that will automatically receive those proceeds upon your passing, you need to make sure that you keep those updated. First of all, fill them out. Jack didn't provide a beneficiary at all. That's a big mistake. You don't want to do that. You want to provide a beneficiary. But then you also want to make sure that those beneficiaries are updated. You know, you don't want to include somebody and then 10 years later find out that that's not the person you want in there anymore. So you want to keep up to date with those kinds of things. Now, another consideration is if you do decide to speak to somebody about your estate plan, a lawyer, make sure that you discuss those beneficiary designations with your lawyer, just to make sure that they coordinate with the estate plan that you're putting together. All right, and you may want to consider whether to name a living trust as a beneficiary under one of those accounts. There are many considerations for why individuals would want to do that. That is your basic planning under a will or under a trust. And remember, one is effective only when you're dead, whereas one is effective immediately, right away, with you being the trustee of your trust. I know I have received some questions already, and I invite questions. I like questions. So my information is on the screen here for you. I invite you to reach out to me with any questions that you have. And I also invite you to return, because as I said, I will be doing another webinar next week, different topic, and then another one week following on Tuesday on another topic. So please keep that in mind. Ask your questions. If you do decide that you want to make an appointment or speak to me personally, I am completely open and available to do such a thing. We are open for business right now. Law firms are essential. We are here working just like we were before, only under different guidelines. We have different procedures that we follow now. You are still able to execute your documents, even under our current situation. You're still able to get your documents executed. We're getting very creative nowadays amidst Corona. We're doing drive-through signing. We have our parking lot open where folks can remain in their car and still get their documents signed with keeping social distancing in mind. So we're still able to get these things done. We're still able to get creative and get the documents signed and get things in place that people need and want to have in place without having to put yourself at risk. We're able to adapt. We're able to get creative. And I am able to do consultations via Zoom, the computer, or just the good old-fashioned telephone. So we are able to do these kinds of things amidst the pandemic. We're not locked inside and helpless. We are able to plan, and it's a good time to do so. We have a little more time for planning now. So I'm going to jump into a few questions here because, as I said, I know I've received some questions. So let me get rid of my slide here and go to my questions. All right. And please, if you think of any questions that you have, by all means, go ahead and ask them. They will come to me here in this format, or if you'd want to shoot me an email or anything like that, you're able to do that as well. I have no preference. You can do either or. But I will take some of these questions that I received. I received a few emailed to me prior. And we have Rebecca here who asked me, what happens if I die without a will? Well, as we discussed here a little bit ago, if you don't have a will when you pass, then if you're in a probate proceeding, your assets will pass according to Florida's intestacy laws. And those are the laws that are in place if one dies without a will or without a plan in place. So if you don't have a will, then your beneficiaries will be determined by Florida law. The short answer to that. Now, the next question I have, which is a double up on that, does a will avoid probate? And again, as we discussed, a will does not avoid probate. A will is designed for probate. It is your instruction sheet to the court, to the probate court. So no, a will is designed to be used with a probate proceeding. It does not avoid a probate proceeding. I have another question here. This is a common one. This is a very, very common one. I have received this question a lot, and actually it's not a question that I get a lot, but it's something that I've seen experienced quite a little bit when people have come into my office. Should I add my daughter to my bank account to make things easier when I'm gone? And again, I've had numerous clients tell me, well, Mr. Baldwin, don't worry, I've already done this. I've already added Judy to my bank account. You know, she's my daughter. I never recommend doing that. I never recommend adding another person to your bank account, your checking, your savings account. Once you've done that, they are an owner of your account. Even if it's for planning purposes, if you put their name on that account, they're an owner of that account. They can take the money out. If they have creditors that are trying to come after their money, they can get their hands on that money that you didn't expect to have happen. If they file a bankruptcy, that money could be at risk. There are many reasons why you don't want to just include a name on an account. There was a client who'd added her daughter's name to her bank account and wanted to leave her money equally to her 3 daughters, but she just put her 1 daughter on that bank account. And so after she passed away, her 1 daughter got to take all that money in that bank account. It wasn't divvied between the 3 daughters. So again, it takes some deliberation, some consideration before you just add somebody's name onto a bank account, even if it is a child. And you'd think that you would trust them. And, you know, a lot of the times problems are out of their hands. So it's not that they're a bad person or that they're not trustworthy. It's a big caveat there to pay attention when you're doing something like that. There are other ways to plan than to just add another name to your bank account. You can do it through power of attorney, or utilizing a trust. Or a lot of times clients will designate a bank account what they call a POD, a payable on death account. So it becomes like a beneficiary designation on your bank account. All of these are much better planning options most of the time than to just go ahead and add somebody else's name onto your account. Okay, so I hope that answers that question for you. Okay, I have a little bit of a longer question here. My father is a Florida resident who just went to hospice care. He still owns his house in Michigan. What happens to that house when he is gone? Okay, well, this is an interesting area of probate. If your father is a resident of Florida and he files a Florida probate, he will most likely also need an ancillary probate, a double probate, what again they call an ancillary probate. It's another probate filed in the jurisdiction where you own real estate. So in your case, Michigan, your father would likely need to file a probate action in Michigan as well, an ancillary probate to deal with the property that's in Michigan. Now, a lot of folks will utilize trusts for this exact scenario. If you were able to hold your real estate in a trust, regardless of where it is across the United States, that can avoid that double probate problem. Or if you own property in multiple states, triple probate, or however many probates you'd need, it would avoid that. You can use a trust to avoid that scenario. So if your dad, who's in hospice, if he still has the wherewithal to do some planning, if he's no longer or if he's still here and in hospice care, if he's still able to do some planning and make his own decisions, then there are some things that you can do here to make that easier. But otherwise, with the information I have here, it looks like he would need a probate filed in Michigan as well. Again, there are a few other things you can do. You know, trust is what I was just talking about, but I'm a licensed attorney in Florida. I'm also a licensed attorney in Michigan, and both of those states are states that utilize a special deed called an enhanced life estate deed or a ladybird deed. And it's another great planning tool that can avoid probate. And it's a deed that's only offered in a limited small handful of jurisdictions, Florida and Michigan being 2 of them. But again, that would be a topic for another presentation. So we're not diving off onto a whole nother area here. But I hope that answers your question. And it looks like I have one more question here that I've got through. Are my assets protected in a trust? Well, I'm not sure. I think what you're trying to ask are from creditors. Are your assets protected or shielded from creditors being in your trust? I assume that's what your question is. And if that is your question, the kind of trust that we were talking about here today, a revocable living trust, that is not a tool for asset protection. That is not something that we generally use for asset protection. You're not able to hide your assets in a living trust and not have any liability to worry about or think that they're safe and cozy there, because a revocable living trust can still the assets in that can still be reached by creditors. When you deal with trust and asset protection, we're getting into an area of irrevocable trusts, which again, that's a different topic all on asset protection in and of itself. So the idea, I think, to take away from your question as to whether or not your assets are protected in your trust, if we're talking about the revocable living trust, as we were talking about here today, one of the two planning tools between a will and a trust, no, there really isn't asset protection in terms of shielding your assets from creditors. That doesn't work with a revocable living trust, the kind of trust that we're talking about here today. So I hope that answers your question. And with that, it looks like we have reached our time here for the presentation this morning. Please, again, I would like to invite you to email me your questions. I can address those during our next topic. And I invite you to come back next Tuesday. Like I said, I will be going more in depth on some other topics, some things I talked about here today, some other things that you might find interesting, and I might deviate depending on what I hear in the meantime, in the interim. People that are asking me questions, I may steer in that direction if I get enough people asking me the same thing. So, yeah, please keep your questions coming. I like this, and I like being able to explain on a community level, so that at least everybody's able to get a little bit of education. Please let me know if this was helpful. We are open and available. We are doing our signings. We are doing it all in a very safe way. So please keep healthy out there, keep sane, and keep your questions coming. I really enjoy that. I really like that. And let me know how I'm able to provide you better information or something else that you would like to see. All right. Thanks, guys. Thanks for the time, and we'll see you next week.